wildlife. They deal with companion animals in domestic law mostly. And that's the problem here. The question that I've then asked is that satisfactory? Now, if you just look at the title of the presentation, Wildlife Rights, that's sort of absurd nearly. No one has written about wildlife rights ever, and it's exactly because of this aspect of let them be. And I'll explain that further. But I've asked the question whether that is a sustainable and satisfactory approach that we have towards wildlife. Especially in Anthropocene, we have anthropogenic activities, such as pollution and causes climate change, for instance. We have trapping, hunting, and captivity. Those are sort of your traditional concerns in terms of welfare. But added to that, we have global implications of habitat loss, as well as climate change, for instance. And these indirect harms, in addition to direct harms to wildlife, make it to an extent unsatisfactory to perpetuate that divide between welfare and rights in relation to wildlife. And that was sort of my hypothesis when I started with the paper. And the question that I then asked is whether it's timely to consider the issue of rights, wildlife rights. One of the major authors and experts and authorities of animal rights in international law is Ann Peters. And she recently published her Hague Lectures in a pocketbook form. And in that book, she also proposes an extension of the international human rights framework with a specific rationale and telos associated to animals. So sort of a zoological approach in terms of the extension of international human rights at the international level. And that's because of the fact that animals need universal rights in a global setting, for instance, in terms of global trade and implications thereof. And she utilizes the so-called vulnerability argument, where she states that humans or human rights are well suited to respond to the current maltreatment of animals. So it's about the vulnerability of animals. And that vulnerability actually changes the question from whether animals should be rights holders to the question or to the issue that they need those rights due to the fact they're exposed to activities of humans and they're quite vulnerable. And that creates a link with international human rights law, similar to what we've seen post-World War II. So essentially, when I asked that question, is this sort of a timely response to the current circumstances? And in addition to the scholarship that I've referred to, I think there's a prima facie case to be made for extending or utilizing the international human rights law regime to animals, but specifically wildlife, as part of the next phase of the development of human rights. But then we go back to that problem of let them be, hands-off approach. Can it really work in relation to wildlife? And that led me to the research question, and that was to critically consider extending or utilizing the IHR framework and apply it to wildlife to establish what I refer to as international human rights like wildlife rights, or in short, IWR, international wildlife rights. And I'll use that second term, international wildlife rights, in my presentation. When I refer to wildlife, I just want to make mention of the fact that I include captive bred animals for conservation purposes as well, and also liminal animals. So it's a broad, sort of a relatively broad definition of wildlife. And now, in terms of the structure, there it is. I just want to briefly refer to the structure. So I've provided with a contextual background concerning the issue, the fact that we're in an Anthropocene, where we also have indirect harms. We have case law bolstering this idea. And now my question is, can we create international wildlife rights due to the vulnerability of wildlife? And that is the research question, talking about international wildlife rights. And the way in which I will deal with it, and I've used this one, I really liked using the colors, but now you can't see it. I don't think you can see it. I'm not very good with PowerPoint. I never have photos and moving figures or anything. So I was extremely proud of this presentation, but it has not worked, clearly. But what I'll do is, in the presentation, there's a narrative. And the first thing is, the first question is that I'll address is, what is the probability of extending international human rights to wildlife? That's the first thing. And then the thing that you can't see there's in yellow, the fit in terms of that utilization of international human rights in relation to wildlife. And then I'll assess ecological objections to this approach, so in a very critical manner. To move on to the next phase of considering so-called generic protection based on intrinsic value of wildlife, and then fine-tuning that sort of approach through the lens of dignity and discussing so-called integrative dignity. And from there on, I'll move to the political viability of the proposal and what I refer to as current hooks in international law that we can utilize that can actually cater for the progressive development of these nations towards an incremental development. And then I'll refer also to some alternatives in what I refer to as an incremental progressive development towards international wildlife rights. And we'll conclude my presentation. So the first part of the presentation is, what is the viability of this? Because Pate has already actually proposed the utilization of the IHR regime, but for domestic animals. What about wildlife? Can we do the same? One of the very prominent and foremost authors in this regard rejected a sort of speciesist appeal to the genotype of Homo sapiens. So stating that not only that humans can actually have human rights. That's the first important aspect. He argues, and it's Cavalieri argues for the extension of international human rights to animals. And the criteria is beings that have an interest in their own welfare. So in their own welfare for themselves and not linked to any external evaluator, human beings, for instance. My motive in trying to understand this is to cater for an international regime, for an international protection of, I refer it to entities. Because what we see, the term used in international law is resources, natural resources. Animals are also considered to be resources. So as if they're not sentient. And that is something that we've also dispelled in recent literature. But so the idea is we need international protection because of the fact that we have these so-called natural resources that migrate, for instance, between countries. And biodiversity clearly has global implications. I've coined the term, well, I've not coined it, but I've worked on the term of so-called global environmental sentient resources. So if we consider that argument of Cavalieri that actually argues for the extension and stating that we can't use the human component of human rights to exclude animals from human rights. If we take cognizance of that, then we see that in a recent publication, Tom Sparks from the Max Planck Institute actually referred to the fact that animal lawyers do not need to reinvent the wheel. They can actually seize and adapt the available normative and regulatory toolbox by applying, for example, established principles of human rights formulation, adjudication, conflict resolution, and implementation to the animal context. There's no need to reinvent the wheel. So we have those components and aspects and tenets in international human rights law. And the question is, can we actually adapt it to the current scenario? The reason, and I'm going back to what I've stated in the beginning, so we have authors that actually, they've indicated there's a possibility to use human rights for animals, although they're not human animals, but non-human animals, because obviously we are all animals. The question is, why not wildlife? And I've referred to that previously. It's because of the proximity between wildlife and human beings. When we have companion animals, we need to shelter them, we need to feed them, we need to protect them, so dogs, cats, and so forth. But wildlife, the idea has always been you have this pristine area somewhere where we should not interfere with, where where predation should actually take place. And there's a concern that if we intervene, then we will actually dilute the concept of wildlife and that pristine nature, that sort of image that exists. So that sort of distance, that relationship, that it's relational, is a counter-argument frequently used for awarding rights to wildlife or interfering with wildlife. There's even a concern, and there's scholarship on this, where scholars have actually made proposals to impede predation through genetic manipulation. So there's that concern from environmentalists that when we go down that route, we will alter sort of the ways of nature, the structures of nature, and the issues of survival and so forth. Now, a good example is an argument by Livingston, which I found very exemplary in this regard. And his concern was that if you then use these rights for wildlife, what will essentially happen is you will disturb the hierarchies and the relations that we find in nature. And I'm not going to deal with all the arguments. Essentially, I think that's sort of a very interesting way in which he sees it. He states that if you use these rights, you will colonize nature, and you will impose these power relations of humans on nature. So it's a form of colonization, essentially. And I think that's sort of a very good metaphor that he utilizes. And essentially will then subjugate nature, meaning animals, wildlife, to the power relations and struggles of human beings. So that's his objection. Now, this publication was written a few years ago already. My response to this quite clearly is that in Anthropocene, where we as human beings are actually agents of change, we're not merely agents partaking in this interplay between humans, nature, habitat, and so forth, but we are the agents of destructive change. Quite clearly, this argument does not hold water anymore. We can't really find secluded, pristine nature somewhere anymore. Even the most secluded area, you'll find microplastics, for instance, there. So in Anthropocene, we've changed the environment to such an extent that all components of the environment are already subjugated to the whims of human beings. So we've moved past that already, and we need to take cognizance of that. The second objection is also linked to an extent linked to that. And that's the scholarship between environmental ethics or environmentalists and ART exponents, animal rights theories. Environmentalism has a very strong focus on the holistic view. So they're not concerned about the individual members, individual animals in the environment. So for a good example is culling. When there's a threat in relation to habitat due to, let's say, overgrazing of elephants, culling could then, in terms of their arguments, be utilized in order to reduce the population to save the habitat itself. Whereby animal rights theories will clearly view that as an infringement on the rights of the individual members of that species. And that is a clash and a divide between those two components. And it's also frequently used as an argument to counter that focus on extending rights to individual members of species. I've dealt with that in a previous publication where I've proposed a welfare-centric ethic based on work of Cochrane, Alistair Cochrane. What I've indicated there is this ethic, this welfare-centric ethic, can be utilized as a basis for the development of wildlife rights. So it's not that dichotomy is also something that we can overcome through a recognition of the interplay between individual members, the holism in terms of the habitat as well as species. It's something that we can overcome. And I mean, if you want to read, you can read the paper, Werner, if you want to know more. I can't deal with everything in detail, obviously, but I'm just referring to some of the aspects, the most important aspects. So, in my mind, this distance, this relational aspect, that actually impedes progression to be made in terms of reaching consensus on the extension of the international human rights regime, is something that we can overcome. This distinction is relational. It's a relational difference, which does not exclude wildlife from the realm of IHR. But it has an impact on the manner in which we have to devise distinct relational rights for wildlife. And this is Inferior. So what I've tried to do is to indicate that it's not impossible. That sort of major obstacle created in terms of ART is something that we can overcome in terms of the conceptual arguments that I've just presented here. So now that we've dealt with those arguments, and for me it is quite that it is indeed a case to be made for the extension of the international human rights framework to individual animals, the next step is, how do we do that? If there's no sort of intellectual objection to this, the next phase becomes important, and that is, how can we actually do that in international wildlife law? Now, the interesting thing is that when I started with this project in it's already 2016, when I started with that and published the first publication in transnational environmental law with a sort of setting the scene, at that stage it was really abstract. And sometimes I wondered whether I was busy with something that would have any impact. But it has now moved on considerably. And we've changed, or the scholarship has also changed to such an extent that there's a clear call for the recognition of wildlife welfare law. And also interesting developments have taken place even in South Africa in terms of bloodlines, where we actually campaigned against bloodlines. So things have moved on. And in international law, environmental law, I think there's a movement towards recognition of the moral worth of individual wild animals. And you can see that recognition of intrinsic value in the preamble of the CBD, Convention on Biological Diversity. Now that's the intrinsic value of biological diversity, not of animals, of wildlife. It doesn't state value of specific wildlife. But biological diversity, one can make an argument that the components making up the conservation of biological diversity can also be linked to the recognition of intrinsic value, and not merely instrumental value or inherent value, but intrinsic value in international environmental law. So this recognition of intrinsic values also underwrites the moral worth of individual animals, which means that there's a clear necessity for the protection of individual animals in international environmental law, and more specifically, international wildlife law. But it's generic protection. And that is something that Bowman also referred to, Michael Bowman, in a chapter that he contributed to a book of ours. So that's very generic. Generic protection of wildlife, wild animals, individual animals. Freedom from, for instance, intervention of human agents in certain aspects. But that does not go far enough. There's a clear need for a specific tailored protection, and if we want to accept this argument of devising international wildlife rights, then we need to have clear rights, specific rights, tailored rights for what I've referred to previously, the additional layers of wildlife. And that's where Michael Bowman, it was a book that I published in 2019, I think, International Environmental Law and Wildlife Welfare, Animal Welfare. And he published an excellent chapter in that book. And in that chapter, he referred to various aspects of the debate. But he also indicated that dignity is a possible hook, essentially, for the further development of specific protective measures. If we use that argument, what we can then state is that if we recognize generic protection, the next step is specific protection to align with the layers, relational layers that I've discussed previously. And then specifically, dignity can be used, animal dignity, to respond to this matter. The problem is that we deal with human dignity always, so we don't really know animal dignity. But very interesting, especially in India, in the jurisdiction, they've had some very interesting cases concerning the expansion of dignity. And I can't go, the publication will deal with, well, deals with all the detail. But what I can state is there's clearly sort of a reception of this idea both in domestic jurisdictions but also in terms of scholarship. And that's where I say, well, my view is that dignity applies to all complex life forms, such as animals, which have been recognized to have intrinsic value. So first intrinsic value to give generic protection, then we can look at dignity. And that's a minimum threshold concept. And for me, dignity is a state or quality of being worthy. I just want to look at my time. I still have some time left, I think. So if we use dignity, and once again with the recognition that the concept frequently in law excludes, well, essentially international law, it excludes non-human animals. How can we use it? Dignity is something that we can use if we accept the fact that we can expand it and that this approach to dignity that we currently have is sort of a very speciesist approach, and expand it and recognize in terms of current science, in terms of sentience of animals, that they can also possess dignity, but their dignity differs from human animals. And the way in which we can use dignity on the basis of generic protection is to use dignity as a lens to view the cognitive, sensory, and emotional life of specific animals. So the rights are tailor-made in accordance with the knowledge that we possess in terms of the intelligence of an animal, for instance, the sensory perceptions, the social bonds, the culture in terms of whales, for instance, that they exhibit. So there's a recourse to be able to evolutionary biology and other scientific fields that will inform the formulation of these very specific rights. And so dignity for me, the term that I've coined, I don't think I've coined it because I'm sure someone somewhere has done that. That we don't easily discover new things, do we? But I do think this form of integrative dignity that I proposed has two components. The one is the ontological claim concerning the status of the individual animal, and the second is a normative principle that determines the implications of that claim in relation to the development of tailor-made specific rights. And essentially, dignity as a state of being worthy is the minimum threshold concept is to prevent animal harm, but also, plus, create conditions for flourishing. And if we refer to human dignity and the origins of human dignity, I think it makes it also quite clear why I'm someone that really supports, I'm someone who really supports this concept of human dignity. Because of the links to an international human rights regime, but also the history of the Holocaust that preceded that. And the vulnerability of human beings, and the necessity to recognize that irrespective of race, color, or creed, or gender, we all have human dignity. And it's the same with animals. They also have integrative animal dignity in terms of what I've just discussed. So how do we view this? I'm not stating that animals, or specific animals, let's take the best example, because I'm currently working on that again. Whales. Whales have dignity, but there's a clear spectrum. And then let's say you have whales and you have seals and you have dolphins and so forth, and then you have human beings. So there's a spectrum, but it's not exclusionary. But there's a spectrum that exists where you can encounter humans on the one side and maybe whales nearer to humans, and then maybe, I don't know, snakes on the very end of the spectrum or something similar. And what we see is we already see in law, once again in domestic jurisdictions, the reception of this idea. And I've referred to one example. There are various other examples. And this spectrum does not create a hierarchy between humans and animals. Human beings, whales, dolphins, and so forth. But it rather creates a recognition of the relational as well as the situational perspectives on dignity, which then also relates to the relationship between humans and animals, plus recourse to those scientific fields that I've explained to give content to rights. So integrative dignity is very important here because of the history of dignity. I think something that we can transpose to the current realm of animal rights or international wildlife rights. And integrative dignity is applicable to complex life forms with intrinsic value on the spectrum. What are the advantages of dignity? In addition to, I think, the sort of perfect fit with the notions of dignity in relation to the vulnerability of human beings. I think the advantages of dignity linked to international human rights law, for me, are quite clear. We can use, for instance, regular reporting to convention bodies as one mechanism, special rapporteurs, mechanisms to allow for complaints of rights and violations, all those mechanisms that we find in international human rights law that can actually complement the current enforcement mechanisms that we find in international environment law, such as the COPs and enforcement mechanisms created by COPs. So I think essentially this form of integrative dignity based on intrinsic value that can actually serve for the development of rights can strengthen international environmental law further, bolster enforcement of international environmental law, but also dilute the anthropocentrism in law. So once we've established, yes, we can have rights, no intellectual objections, yes, we can perhaps use dignity, but a different form of dignity, integrative dignity, then we can really move towards creating rights. And rights would then depend on those dignity-linked interests, so that the dignity protects certain interests. And I've given two examples there in terms of the two components of intrinsic value, a phenotype and a genotype. So the genotype, I think, already exists in law. That is the issue of extinction. Rights have an animal not to become extinct. I think in terms of current law, we already have that in law. It's not formulated as a right, but we can find that in law. I think the other interesting thing is the more interesting and progressive idea is the good of its own rights, where you protect fundamental interests such as a prohibition on cruel, inhuman, and degrading treatment. Whale hunting, very good example. It is always ab initio inhuman. And there are resolutions to this extent of the International Whaling Commission. So I think that is the interesting thing that we can also focus on in developing then these rights or these interests linked to dignity to move towards rights. In the publication, I've analyzed various proposals for wildlife rights. Those are not declarations, not conventions or treaties, and not custom international, not sources of international law. But for instance, the right to cetaceans was a declaration authored by experts at a meeting. So these declarations have no soft law power and now no standing whatsoever in international law. But I found it quite interesting. So what we can see is we currently have no treaty law or any other source of international environmental law that actually give a court to international wildlife rights. Doesn't exist, and I must be honest about that. So this work is very much the lega ferenda. It's what law ought to be, based on the hooks that we currently have. Are these reasons for despair? I don't think these are reasons for despair. One colleague of mine, Stucki, Saskia, has actually, from the Max Planck, has recently published a very interesting book on this matter. And what she does is she makes a distinction between weak and fundamental rights, animal rights. And I've always also found that there was a bit of confusion when we talked about welfare and rights, because the distinction does not per se relate to the level of protection. You can have higher protection with the welfare regime than you can have with the rights regime. So not necessarily a clear designation of the level of protection. And in the work that she has done, she's also made it clear that essentially what we have, we already have simple animal rights, as she referred to it. In terms of the current welfare regime and welfare legislation for domestic and companion animals, the protection to an extent already exhibits the traits of rights. And there's a possibility for that form of weak rights to become stronger rights in incremental manner, to bolster the existence or creation of stronger rights. So there's clearly a potential here. And that's where I also found that we, in the current work that we are doing as international wildlife scholars, there's a need to strengthen the normative wildlife welfare framework. And various scholars have called for this. And there are two examples. And that could be an avenue for so-called simple animal rights towards a progression towards stronger fundamental rights based on the schematic structure that I've just indicated. And to go back to the quote of Sparks that I've made previously, we can latch onto current developments, the rights for nature discourse that currently exists, the Harmony with Nature initiative, the current resolution adopted in October on human rights and environmental protection. All those things provide interesting hooks for the incremental and progressive development of so-called international wildlife rights. And we can move from so-called derived rights to stronger rights. And you can see the quote that I've given there of Pinto de Albuquerque in the Herman versus Germany case, the separate opinion. We also indicated that, or which gives a core to that idea of weaker and stronger animal rights. So there's a possibility to use all of that. And in doing so, we can actually create, and this was one of the arguments that I frequently made, if we have on the domestic plane these developments, especially when you have an adjudication of cases in relation to animal rights, that creates a global dialogue in terms of Anne-Marie Slaughter defined as transjudicial communication in her work in the 90s. So that can also create from the domestic plane or bolster this initiative that we currently have. And we can already see that it has taken place. So in that sense, global environmental constitutionalism is also a promising avenue to strengthen this idea of so-called wildlife, international wildlife rights. And then in addition to that, what I've mentioned is the international right to the environment in the resolution of the General Assembly. So essentially, what have I proposed here? There are various different layers to this idea outlined in the publication. And initially when I wrote it, I think I ended up at 14,000 words because you deal with all these different aspects, and I had to reduce it to something that is ref-returnable. And it's now, I think, at 12 or 11,000, which is more readable and more structured and more coherent as well, because initially it was not. But the whole idea is, in conclusion, I would like to make mention of a few things. The first thing is what we've noticed in this discussion. Remember what I said in the beginning. The question here is if we can utilize animal rights or so-called human rights for animals, why can't we do it for wildlife? And I've indicated there are no objections anymore to that idea. And it's not merely, therefore, this development of international wildlife rights is not merely an absurd intellectual exercise. Because when I started off with this, I thought maybe this is just sort of an egocentric intellectual exercise. But it's not anymore, because we see it being actually confirmed and affirmed in domestic jurisdiction. But rather, it's the next, in my mind, and I think I've taken this from the publication, it's the next the next logical progressive step in animal rights theory, but also in international human rights as a subject. It is essentially about the completion of the recognition of the integrative dignity based on the welfare-centric approach in response to the vulnerability of all animals. And we are also animals. So all animals, human and non-human. It's an incremental, integrative approach that will actually dilute anthropocentrism. And it affirms our position as animals that share the fate of other animals. We survive and we die. And if we have that understanding and recognition, it will also diminish our destructive anthropocentric approach to things. So my proposal is that yes, there's a possibility based on the tenets of law to create international wildlife rights, but it's an incremental manner, and we need to also use the current welfare regime in order to get there. And we need to be very specific in relation to the utilization of dignity. And lastly, I can then conclude with a quote. It, he thought. She keeps calling the owl it. I don't know if you know that quote, but it's from one of my favorite books. Thank you very much for your time, and I am ready for any of your questions. Thank you.
Thank you very much, Professor Scholtz. Thank you, Professor Scholtz, for that very thought-provoking presentation. To my mind, there are so many parallels between the Earth jurisprudence and rights of nature movement, and I have questions regarding implementation and so on, but I think I'm going to give then over to the audience. If anyone has a question, we have about just over 10 minutes.
Hi, thank you very much for the presentation. You made mention that better protection can be achieved under a welfare regime than under a rights regime for animals. Are you maybe able to expand a little bit on that and maybe give us some practical examples?
It's not a better protection necessarily per se, but there are instances where the level of protection can be better. If you have can you hear? I'm not sure whether it's working or not. If you have, for instance, rights that are extremely weak and not well formulated, it does not give a clear indication of a level of protection. But it is possible for a welfare regime to offer a higher form of protection. We have, for instance, let's say trapping is a good example. That's a horrible example, actually, but a good example. So in terms of trapping, you can utilize scientific knowledge in order to determine the time to its death, since an animal has been trapped. Then you use ethical judgment in order to determine whether that is morally viable. But you have very clear, specific time requirements, also in terms of details of instruments to be used. Once again, a very horrible, they should just prohibit it altogether. That's an example. And you can have a right whereby it's stated an animal should not experience a long death or something similar to that. It's about level of protection. My idea is not to position myself for rights or welfare, but it is to take cognizance of the fact, and that is also in line, I think, to an extent, with the scholarship of Gardner, for instance, where indicated that we can use welfare regimes, and you can use that as a basis. It offers a level of protection. It is not as strong, for instance, as right to life. Let's take whaling as the best example. So we have a moratorium on whaling, 1982 moratorium for commercial whaling. But we still have whaling being conducted in terms of scientific whaling as well as ASW, Aboriginal Subsistence Whaling. So you have that. But you have a sort of an upcoming welfare regime in terms of the issue of humane killing. But there's no right that exists currently. So what we need to do is use that regime that is gestated in a convention and build on that further to move towards a right to life for whales. My most recent publication, I've not started writing it yet, I've just finished the structure and everything, deals with that aspect. And it deals also with Aboriginal subsistence whaling, but also the culture of whales. So that's quite interesting. So I'm not positioning myself. I do know that so the idea is if you have wildlife rights, the one thing is it offers stronger protection in terms of when you have a balancing of interests. Because then you can have human rights of humans and human rights of whales, for instance, and that balancing is stronger. When you have a welfare regime with human rights, quite clearly, human rights will be stronger. So I take cognizance of that, but I also take cognizance of the fact that it's not useful to merely state that in all instances, the welfare regime will be weaker, because it's not true. So conceptually, we need to understand the issue of the level of protection vis-a-vis the nature of protection, and that is important. And the idea is to move to its stronger protection, whereby for certain animals, and whales, whales the best example, because I'm in favor of the right to life for whales and the right to culture for whales. So that's where we want to move to. I don't know if that answers your question. Okay. Thank you. Yes.
Okay, so you were speaking about the concept of integrative animal dignity, and then speaking about wildlife on a spectrum, where you use the examples of whales being closer to human beings. Would creating these hierarchies within wildlife, as well as distinguishing animals such as farmed animals, wild animals, domestic animals, would this not just create a bigger issue in law than rather just trying to classify animal rights in international human rights?
So, oh no, sorry. So I understand what you're trying to say, because essentially what I've referred to in terms of that spectrum sounded like I created a hierarchy. That was not the idea to do that. I've just indicated that what I wanted to indicate is that you don't have, this sort of creation of hierarchy between here we have humans and here we have animals. What I wanted to indicate is that it's integrative, extensive. So it's not merely for human animals. And that is a concept of what I refer to as dwelling. We are all mortals on this planet, and we've, through different facets of our development, accorded ourselves these supreme rights to rule over everything. What we do have is there is a distinction to be made, that is important, between domestic, companion, and farm animals vis-a-vis the specific rights of wildlife animals. That is very important. It's relational and it's situational. You can't disregard the fact that our relationship between, I have a working cocker spaniel at home, she's quite crazy, anyway, but I need to feed her, I need to take care of her, and I need to walk her. I'm not going to feed a lion, I'm not going to walk with that lion because he will devour me, and it's within his right, obviously. So you need to make that distinction, and therefore my proposal is, yes, so the first thing is we have dignity, integrative dignity for farm animals, for companion animals, for human beings, for wildlife, but then that dignity via recourse to the relation to its human beings, but also aspects such as biology, whales being a very good example, the work of Hal Whitehead on whales is a good example. You use that to have those specific rights. It does not exclude the fact that other animals have those rights. And it's not about a hierarchy, but it's about the fact that you recognize the layers of difference because of the relationships that exist between humans and animals. I have a different relationship with a farm animal, different with a companion animal, and it's different towards wildlife. I'm very much object to the idea that, and concerned about the idea that you'll use this extension of rights to conduct genetic manipulation in order to end animal-on-animal predation. It's absolutely wrong and ludicrous. And that's where you end up if you don't have that distinction. So I'm very concerned about that and against it. So there must be some sort of respect also instilled for nature, if you can use that concept, and environment.
Thanks. We also have a question here.
Thank you.
Vessel.
Yeah, thank you, Werner. I must say, your idea doesn't resonate with me. And I'm sure this is a stock response that you hear frequently.
I don't. I'll be honest.
Oh, okay. Why it doesn't resonate with me is I'm worried about the effect it might have on the discourse of human rights. Because it seems to me that there's a critique against the reduction of human rights to humanitarian rights. So it becomes a right to humanitarian protection, and then that turns quickly into a right to humanitarian intervention. And then you have a very problematic hierarchy where human subjects and citizens are reduced to the beneficiaries of human rights. That should not happen to human rights. And it seems to me if you extend the human rights paradigm to welfare and animals, you are becoming a victim of the humanitarian reduction of the human rights idea. So the focus on dignity separated from democracy and citizenship, for example, is one point. The focus on mortality in your talk as opposed to natality. If you take on a rent as a frame of reference, is another point of reference. So there's a lot of recurring themes, but I think the overriding idea is, while I'm fully in support of greater protections for animals, I'm scared that if you use the human rights paradigm to do it, the price that humans will pay for this reduction is something that must be factored into your discourse. And to explore this other alternative, say the welfare paradigm, whatever, I'm not an expert in this field, rather than to contribute to the animalification of human rights, if I want of a better phrase.
Thank you. Thank you. That was quite thought-provoking, Wessel. Maybe just a few things, and I think I will not be able to respond to everything now, but I think we need to have a follow-up conversation on this. The critique that I've had, or frequently critique that you will have in relation to this idea, is that if you make this proposal, you essentially dilute the human rights framework that currently exists. That's the typical thing that I've heard. A colleague of mine has written on human dignity and human rights, and he was actually even concerned about these new so-called human rights, a right to the environment, because he felt that there could be sort of a dilution of the human rights framework. So I've not heard that response yet. My idea is not to create new areas of power, of intervention, but it is very specific, and it's maybe quite restricted and restrictive as well, in the sense that, let's take a good example. So generic protection, we all can agree there should be some form of generic protection based on intrinsic value. We can all agree that we need to expand the current welfare regimes in international wildlife law. That's quite clear. To an extent, it's already incidental in CITES and so forth. But my argument is not to have a register of all-encompassing rights being plucked out of the air all of a sudden, but in terms of that concept of integrative dignity, to focus on very specific representatives of representatives of wildlife. And for me, a good example would be whales. The recognition in terms of science that there's clearly a right to life. What are the implications of that? It will not have a negative effect for me on human rights or lead to some form of humanitarian intervention. What it will have is it will solidify the notion and the sort of global conscience of human beings that it's immoral to hunt whales due to the very sort of cruel nature of whaling, first of all, the fact that you don't benefit at all from that in any sense. And the third aspect is that because of the majestic way of these creatures and the current biological science that exists in relation to the intelligence and culture and so forth. So that it will just lead to that solidifying the current moratorium to stop all forms of whaling. It will clash with the Aboriginal subsistence whaling, which is an expression of right to culture. But I'm not going to respond to that because this is a new publication that I'm writing. But that's not the idea, that it dilutes human dignity or that it dilutes the human rights framework. And it's not all encompassing all of a sudden. So you need to have used integrative dignity to formulate very specific requirements for those vulnerable species. So it's not, and just in terms of intervention, the one thing that I can think of is the fascist, eco-fascism, for instance. That is, of course, a danger that can exist. But that's a very sort of a holistic response and view to things. And I think there was an argument that an article that I've written many moons ago on security and environment in 2010 in the Yearbook of International Environmental Law, where I actually dealt with that issue. If you expand the concept of environmental peace and security, will that then lead to so-called green helmets? There was a publication of Linda Malone at some stage. Will you then have these green helmets interfering? But that's not the idea. It's not about reducing or taking away, but giving recognition to scientific concepts, recognition of sentience and moral worth of animals, and in an incremental manner, strengthening that further. But I would like to have a discussion with you during lunch, if you don't mind, to take it further. Thank you. That's a really good question, Wessel. Thank you.
Hi, is this on? I just wanted to ask, how would you suggest we implement wildlife rights when there are countries that are struggling to implement basic human rights?
Oh, that's an even more difficult question, obviously. So the issue here is that we have this global or international shared values that I've based everything on that concept, obviously, that we have these international human rights that exist all over the world. And the fact that it is implemented and complied with all over the world. And that in the next phase is that you can have something similar for animals. But it's obviously true. Compliance and enforcement is a major issue. You also have reservations being submitted to treaties, for instance, in relation to gender issues. That is another issue. Then you have cultural relativism, which also dilutes frequently the protection of human rights. So I fully understand it deals with the issue of capacity on the one hand as well. I don't think the fact that you will create a regime for the protection of, or that should be an excuse for the creation of the protection of wildlife. I think that is because these are international human rights. I think what needs to be done is it needs to be some sort of a generic instrument created first of all, which can then afford protection or give recognition to that. And subsequent to that, you will need protocols and further treaties in order to deal with the specific animals. But once again, I want to stress the fact that I'm not all of a sudden contemplating 500 different treaties, and all of a sudden we'll have rights of springboks and an impala or something similar. That's not the idea. So it's very much in terms of the hooks that exist and the concept of dignity as a lens. That's why I tried to come back to Wales. For me, that's the most receptive area. It's ripe and ready to be plucked, to be used. And I think so with international concerted effort, as well as shared responsibility. I've written a recent chapter on the globalization, I can't remember what the title is, but anyway, the globalization of animal welfare, where you then have, in terms of the common concern of mankind, you have a regime of the sharing of burdens as one of the consequences of that designation. So there's a possibility, similar to common with differentiated responsibilities. So there's a possibility for international actors to share that, because the fact is whales, even elephants, have global dimensions in terms of biological diversity. The hunting of whales have global dimensions. The one thing, apart from the fact that you have dwindling resources that those species migrate, but you also have that on the conscience of human beings. It's in the culture of the market tribe to hunt whales, but it's against the culture of the Maori. It's totally against their culture. So those are some of the aspects that we can think of. But I think what we should not do is state that we can't even keep up the human rights regime everywhere, or it's difficult, that compliance and enforcement is an issue. Let's just disregard everything. Because that's a very slippery slope. Because then you could say, let's not afford protection to this vulnerable group, or that vulnerable group, or let's just focus on this group, or just this form of protection. So from a logical and legal perspective, I'll be really concerned about that argument. Rather, I think we need to respond through a strengthening of support and regimes in order to respond to those issues. Thank you.
Great. Thank you, everyone, for participating today. Really appreciated the questions from the audience. And for you, Professor Scholtz, for giving us your time. We are definitely going to invite you back to hear about the next publication. It's so interesting to see how your thoughts are developing, but also scholars in the field, and law will hopefully follow too. Thank you for our online audience for joining us today. And for those of you who are here in person, there are some light refreshments waiting for you outside. Thank you.
Thank you very much. Have a good day. Thank you.